Welcome to Inside Academia, the weekly program where we take a look behind the ivory curtain seeking a frank discussion of American education. I'm your host, Andy Nash. My guest today is Mr. Edward Whelan. He's president of the Ethics and Public Policy Center and directs their program on the Constitution, the courts, and the culture. He's also a lawyer and a former law clerk, formerly to Supreme Court Justice Antonin Scalia. He also specializes in constitutional law and the judicial confirmation process. Edward Whelan, welcome to Inside Academia.
Thank you, Andy.
You're speaking right now at the Intercollegiate Studies Institute conference in Princeton University, in New Jersey, and you're talking about the concept of a Supreme Court confirmation process being a political triumph for judicial conservatism. That's a lot of what you write about at the Ethics and Public Policy Center. I would like you to define for our viewers what exactly is judicial conservatism.
Well, judicial conservatism respects the proper role of the courts in our constitutional system. It involves, among other things, the original public meaning interpretation of the Constitution. The Constitution has a fixed meaning that's accorded by its original understanding and isn't something that can mean whatever five justices of the court want it to mean. It involves judicial restraint rather than liberal judicial activism. And it involves judges being impartial, consistent with Chief Justice Roberts' umpire metaphor, rather than judges who invoke their empathy on behalf of favored parties, as President Obama's empathy standard called for. So those are some of its hallmarks.
Okay, many folks within the judicial realm and the legal realm refer to the idea of a left-right split in the courts as being a contest in between where the one side says let's interpret the law for what it's supposed to be, versus the other side that says they want to basically fight for certain outcomes. Would you agree with that paradigm? Is that a fair characterization with respect to the contestation going on within the court system at the Supreme Court level in America today?
Well, I think basically, yes. I think the left for decades now, under one label or another, including that of the living Constitution, has been advancing a theory of constitutional interpretation that would enable justices to invent all sorts of rights that entrench the left's agenda. And the opposition to that from conservatives rests on the notion that, no, the Constitution has a fixed meaning. There are issues that are left to the political processes, to the legislatures in those various states and in Congress to address and revise over time. It's not up to the Supreme Court to impose its own views on these issues.
I dug up an old article in the Washington Post. It's about 10 years old, from a Simon Lazarus, who argued that judicial activism should be defined by a willingness to strike down laws and regulations, and that a quote-unquote new constitutional philosophy has attracted numerous adherents on the political right, including at least 3 members of the Supreme Court. Now, the question with that is that there are a lot of people on the political and socio-cultural right and the economic right who, no differently, would like to see certain outcomes come about from Supreme Court rulings and federal court rulings one way or another. So how do you define or distinguish an adherence to law versus simply the left-right clamoring for the outcomes of certain kind of rulings to favor, one person's ox getting gored versus another?
Well, that's a good question. At bottom, what you need to do is establish what the proper method of constitutional interpretation is. And once you establish that, then the question is, what is yielded by application of that method of interpretation? I think a proper method of constitutional interpretation is going to leave all sorts of issues to the legislative branch to decide. So it's not going to please some folks on the right who want to see their preferences entrenched, and it's not going to please folks on the left who want to see theirs. But I do think that on the vast bulk of issues, it's the left that seeks to have its position entrenched, and it's conservatives who say, we don't think the Constitution imposes our view. We think it's up to the legislative processes to work out. Take, for example, the issue of same-sex marriage, or the issue of abortion, or the issue of capital punishment. On all of those issues, the left takes a position that the Constitution should be reinterpreted to impose the result they want. And conservatives almost uniformly take the position that the Constitution simply doesn't speak to those matters, and it's up to the people in the different states to sort out whether there should be same-sex marriage or not in that state, whether abortion should be lawful or not in that state, whether capital punishment should apply or not in that state. So I think that really is a broader model. But more broadly, I think you see an effort by folks on the left having pushed for liberal judicial activism all these years and having had that term earn the stigma that it's acquired, to try to cast that term back on conservatives and use a label of conservative judicial activism. No question that there are some results that some conservatives seek that would be conservative judicial activism, in my view. Mm-hmm. But again, my broader point is that when one looks at the whole range of issues, it's the left that seeks more liberal judicial activism, and on the right you see predominantly a preference for judicial restraint.
I see. So the vast majority of attempts at judicial activism is of the left-wing variety, as opposed to a culturally or economically right-wing. Okay. I want to tie this into academia, if I may, and law schools. I know we can make the argument that a lot of this is sort of cultivated and incubated, if you will, in the law academies. I don't know to what extent you may find that to be the case, but to the extent that it is, do you see these predispositions for students coming in before they reach the academy steps, or is this something that they're pretty much blind to, in your view, and then they're either inculcated into like a left-wing sort of judicial activism type of idea, or a federal society type of model that argues for those restraints that you mentioned earlier?
Well, law school faculties are overwhelmingly dominated by disciples of the Warren Court, for folks who celebrate the liberal judicial activism of the 60s and work to defend and extend the wrong precedents that were imposed during that period and its aftermath. So I think what happens is most law students come to law school not really having very firm views on constitutional interpretation, and they then suffer 3 years of miseducation, including a course called constitutional law that is really largely a course simply in recent Supreme Court decision-making and has typically very little to do with understanding the Constitution as it was adopted. So it really is a process of, I think, a massive miseducation. And of course, once you graduate from law school, people are inclined to think they know something about the Constitution, and it'd be rather daunting to recognize that, in fact, they know very little about it.
So in your view, to I guess change the public perception of what the proper balance of judicial restraint should be, does that change have to start in the academy, or can it just happen in the court of public opinion, if you allow for the pun, to take place, or in the media, or where can this happen? Where does the reform begin to take place?
Well, it's essential to continue to reform the law schools. The Federalist Society over the last 30 plus years has done a tremendous job making improvements in law schools and providing havens of sanity for law students. It's still very much an organization that is overwhelmed by the contrary forces, but it's been incredibly effective. And I think we need to encourage law students and good faculty members to continue to work with each other to develop sound thinking and to resist the dominant misunderstandings in law school. More broadly, I think people need to be educated from the beginning to understand that what our system of self-government is really all about is largely working these issues out by ourselves through our legislators, and not expecting the Supreme Court to come and impose a one-size-fits-all solution to any problem simply because we think we have strong feelings on it. So one would hope that there would still be good civics education. I think that seems to have disappeared even at the grade school level. But the problem is pervasive, I'm afraid.
Right. So tell us a little bit about the organization that you're with, the Ethics and Public Policy Center, and the program that you direct there on the Constitution, the courts, and the culture, and how, I guess, through that avenue you're trying to get these ideas out there.
Well, thank you. The Ethics and Public Policy Center was founded in 1976 on the bicentennial of our country, and it's dedicated really to applying the Judeo-Christian moral tradition and our nation's founding principles to the broad range of public policy issues that we face. So we have programs on a whole range of issues. We're addressing health care, the budget, foreign policy, you name it. My own program is focused on the courts. I'm working to advance principles of original meaning, jurisprudence, and judicial restraint. I've been doing a lot of blogging on National Review Online's bench memos. I've been working very closely with senators and their staffers on judicial confirmations, including the Supreme Court confirmations. I had the privilege of testifying against the Elena Kagan nomination last year, and really am working through writing, speaking, and consulting to try to advance a sound understanding of the Constitution and of the judicial role.
Now, you mentioned a Judeo-Christian set of values in that. A lot of folks who may be not familiar with your work may interpret that to mean that you have some sort of religious or non-secular imposition on the ideas of law. Could you elaborate on that and sort of set the viewer straight on where that comes in and where it does or doesn't apply, or how?
Sure, I'm happy to do so, and it's a good question because a lot of people do think anytime they hear any reference to Christianity or the Judeo-Christian tradition that we're talking simply about imposition of sectarian views. Look, our nation, Western civilization, is founded on a Judeo-Christian moral tradition. This is a tradition that can be expressed and understood in natural law terms. It's accessible to all folks through reasoning. My own thinking and reasoning is in entirely secular terms. No one's going to find any references to religious doctrine in the way that I write, and that's not the way I think about these issues. Ultimately, of course, I do believe that the core principles of inherent human dignity, the principles set forth in the Declaration of Independence that all men are created equal and are endowed by their Creator with certain inalienable rights, are founded in our Judeo-Christian moral tradition, and our mission is to advance and defend that tradition. Excellent.
All right. Well, then I wish you good luck there at the ISI conference, as well as with EPPC, with all your work on the judicial confirmation process for federal justices. So I want to thank you for joining us on Inside Academia, Mr. Whelan. This has been Inside Academia with Andy Nash. Check us out again on the web at insideacademia.tv. Please join us again next week, as every week, as we take you for a look behind the ivory curtain.